Photographers obviously deal with copyright law very frequently. As any IP lawyers know, a copyright is something that you have created and fixed into a tangible expression. And I draft my agreements so that my photographers keep all their copyrights and license those images for use to their clients. One of the things that I like to do is explain to my photographer clients, if they're not familiar with copyright law, which most of them are, which is great because I think photography schools and photography blogs and everything have really picked up that area as a place that photographers need to be careful, is explain to them what that means and why they should keep those rights in their work. So what I like to do is retain the right to use any and all photographs for advertising, trade promotion, exhibition, or any other lawful purposes. If you are transferring a copyright as a photographer, you need to fill out a copyright transfer agreement. I don't recommend doing this. Like I said before, I would recommend licensing those photographs, but sometimes you do transfer the agreement. Or even if you're writing a licensing agreement, it's good to know how to do that. One of the questions that I think has been a little unsettled is, are you allowed to use e-signatures to transfer a copyright? I have heard several attorneys discussing it, not knowing whether the Copyright Office in its language allows e-signatures when it's said, because of the way that it's set up. But in July 2013, the Fourth Circuit did hold that the Copyright Act's requirements in 17 U.S. Code 204A say that a copyright interest can be transferred in writing signed by the owner of the rights conveyed, and that the electronic transfer of those rights is permissible under the Federal E-Sign Act. So that act provides that an electronic contract can't be denied legal effect merely because it was created by electronic means, and that's under 15 U.S. Code section 7001A2. So I've had discussions with other attorneys where they've said that, no, you have to get everything in writing, you can't e-sign, but know that you actually are able to transfer those copyrights. So there is a bit of a sticky area to watch out for when it comes for employees, independent contractors, and works made for hire. So as you probably know, employees, when they're working for their employer, create works made for hire under the Copyright Act whenever they fix something in a tangible means of expression. Independent contractors, on the other hand, have to rely on copyright assignment agreements. Now, the background theory behind this is that employers have a great deal of control over their employees when they create a work, over how it's created, when it's created, with what tools it's created, and really have the final say over how it's produced. And whereas independent contractors, due to the nature of an independent contractor, those works are much less heavily supervised, and the person employing an independent contractor has a lot less say in their creation. So that's why you get the employee-employer relationship automatically having a work created for hire. Many, if not most, people working in the wedding industry, your clients, will have any of their people working for them listed as independent contractors. Now, whether they are independent contractors or not is means for evaluation by you. That's a whole different day of a discussion to have. But if they are listed as independent contractors or as employees, know that it is very wise to have in your agreement that you draft for those for your clients that are employing other people, that they get an assignment for any work not considered a work made for hire. So that way you're covering your bases. Be careful, though, because in some states, even using the phrase or mentioning the phrase work made for hire can be some sort of evidence of an employer-employee relationship. So don't overcover your bases and say, like, all of these works are considered works made for hire, and then we also get everything else, anything else is assigned to us that's not considered work made for hire. Because especially if you're in one of those states where mentioning that can possibly point to an employer-employee relationship, which then involves paying into unemployment, paying workers' compensation, back taxes, things like that. You don't want to get your client in trouble. So make sure you're familiar with those rules and what those assignment rules need to say. Photographers are often very picky about the way their work is reproduced, especially on social media. So a lot of times you're going to have photographers come to you and say things like, I don't want my clients to be able to put it on social media and crop it, or I don't want them to be able to edit it and use like filters and stuff and make it not look good. Because the photographer's product is that digital image, and anything that makes any changes to that can impact their brand or can impact the way that their product is presented to the public. And it bothers them. It's their art, and it's something they created. Technically, when a photographer's client takes an image from the photographer and shares it on social media, it's reproduction of and distributing a copyrighted work. A lot of times photographers don't care and actually really like this because it gives them free marketing and advertising, and people see those images and say that they want that photographer for their event. So it works out very well for photographers. However, like I said earlier, they don't want those images kind of messed with in any way. So the way to address this is to contract around it to give a photographer's client the license to post pictures or to redistribute those pictures on social media, but carve out a section that says that they can't edit those images in any way. Say something, address the filters issue. Say, no filters may be used, no crops, no edits, no changing the size or pixel orientation. Things like that you can draft into your agreement, and photographers will really appreciate you for putting that in there. One exception to this is the use of Instagram. Instagram is an extremely popular tool for photographers to getting their work noticed and getting other clients. It's an extremely useful tool in the wedding industry. But Instagram requires a 1:1 orientation, square orientation for images, and a lot of the pictures that photographers take don't fit those parameters. So instead of prohibiting all use on Instagram, what I tend to write in is an exception for Instagram where you are allowed to use Instagram and it's inevitable crop, but no filters may be used. So that usually will give the photographer peace of mind that their work isn't going to be compromised, while also allowing them the benefits that come from clients sharing their work on Instagram. One of the next things that needs to be addressed are model releases. I touched a little bit on this before the break with planners, but I'm going to go a little bit more in depth into it right now. So when do photographers need model releases? And a model release is something you get whenever you have a picture of a person and you're using their likeness. There are two questions that you need to ask yourself. The first question, is the photograph going to be used for advertising or trade? Now, this means submitting to industry publications, using on the photographer's blog, using in any sort of commercial business purpose, including brochures, websites, portfolios. It's a very, very broad definition. Courts have taken a broad stance on this whenever you're using it for advertising, trade, or commercial purposes. Now, if the answer to this is yes, the second question, can the person in the photo be recognized? Would they be recognizable? This is also a broad definition. There's a broad view on this. If you can recognize anything on them, anything that makes them unique or individual, they can be recognizable. It's not just their face. It's not just, being able to see their smile. It's, would someone looking at this photo be able to know that this was this person? If the answer to questions 1 and 2 are both yes, then you need to get a model release for your photographer to be able to use those pictures in any sort of commercial means. Now, a model release doesn't have to be long. It can be the front of a page. You can pull out your handy-dandy app like we were talking about earlier and have those guests or couples sign those model releases if you know that that's a photo you're going to want to use. Or in a kind of worst-case scenario, you have to go around afterwards, after you take the images and edit the images and figure out that you really like this picture and you want to use it, your photographer wants to use it for their promotional materials, then they have to go back through the couple that they worked with and find out who that person was and then mail them the model release and have them sign off and send it back. Now you need their name, their age, the date of signing, and just a signature of the person and saying that that person's granting the photographer a license to use their image and likeness in advertising, trade, and for commercial purposes in any and all media now developed and later developed. And that way you'll cover all your bases. That way if there's some sort of technology that comes about in the next few years, like holograms or something that we don't have now, they'll be able to still use those photographs. Another concern that I don't think a lot of photographers know about, while they may know about model releases, they don't really know about property releases. Property releases are the same thing as a model release, except for some sort of either physical or intellectual property. Now, when do photographers need to use property releases? They're going to ask 2 questions again, just like above. One is, can the owner of the property be identified by anyone looking at the photograph? Now remember, when thinking about owners, corporations are people too. So if there's something that you would automatically know a corporation owned, such as the property, such as a farm property, and a corporation owns that property, you need to get the corporation to sign off, not just the farmer on the land. If there is a trademark, you would need to get a corporation to sign on that as well. Now, you're going to want to watch out in here when you're taking photos that may have either team logos or brand logos, billboards, any sort of branding at all involved. Bar pictures, you're going to have the bottles of whatever kind of alcohol is there. If you can see those logos or those brands, you're able to identify them. Any sort of branding on clothes or in the background of images, you're going to actually need to either blur that out so that it's not easily identifiable, or you're going to need to get a release. The second question, again, is the photo going to be used in advertising, trade, or commercial purposes? And if it is, if the answer to both of those questions is yes, you're going to need to get a property release. It may be easier to get some property releases than others, but know that if you're going to be using it to promote your business, or even for another person, such as a planner or another vendor that may want to use your photographer clients' photos, they're going to need to get that release as well, or else they could be fined, or they could have some sort of damages that come out of it, especially if the photograph is sold or used in some sort of magazine or industry publication. One of the clauses that I like to put in is a no specific images clause. This protects your photographer clients from, if they miss something for any reason whatsoever. It's a standard clause that says the photographer is not responsible for any one image or one moment capturing one event at that wedding or at that event. An example of this is a photographer is trying to take pictures during the first kiss, which is a pretty iconic moment after a couple is married. And a guest stands up in front of him and ruins the shot, and the photographer doesn't get it. If you have a no specific images clause, that means the client can't turn around and refuse to pay in part or in whole that photographer for missing that one moment. So that's just a good thing to have in there, just in case that happens. Also, you are able to reserve which photos you're editing and turning over to the client. Make it clear that that photographer's client is not going to get every single image taken during the event, nor will the photographer edit and touch up every single image they take. Sometimes I have talked to photographers where their clients expect to get thousands and thousands of pictures back, outtakes, pictures where someone's sneezing. They expect to get all those back, and the photographer has to say, no, you're only getting the ones that I've looked at and edited and have worked on, and I'm taking, I'm not going to give you the rest of those. Make sure that in the contract you draft for the photographer that's very clear. Also, there is a handy clause to have that limits recovery in an instance of film or technology malfunction. I have heard of cases where a couple is very angry that the photographer's technology is malfunctioned, say their memory card, something happened and it erased part of the photos that were taken, or maybe an hour or so, and the couple sued the photographer for emotional distress and pain and suffering. I don't know how that will go actually in court, but the fact that they believe that they have grounds to stand on is just indication of why you need to be able to draft a section of the agreement for your photographer that limits the recovery to whatever the value of the contract is worth. So, in other words, you want to make sure that the couple doesn't turn around and sue for $1 million in pain and suffering on a $5,000 photography contract. A huge area that I always worry about for all of my vendors, not just photographers, are the styled shoot. Styled shoots are extremely popular. If you go online, go to any industry blog, there's going to be numerous styled shoots. And what these are essentially staging fake weddings to where a bunch of vendors come together and they do everything that they like and make everything perfect and kind of go over the top and show what they can do to have images for promotion of their company, whether it is flowers or the wedding planner, the photographer for their photography skills, sometimes dress shops for the dresses that they donate. Anyone who's involved needs to sign agreements that address the following issues that might happen. One of the things you need to think about is who is responsible for what, who is going to be in charge if something goes wrong, what happens if someone falls and hurts themselves, whose insurance is liable, are you on are you on one of the vendor's property? Is their insurance going to cover that? What happens if some of the props get stolen? What happens if the model injures themselves? Those are things you need to set up beforehand so that you're not addressing them on the back end once something happens. And again, once you draft a styled shoot agreement for your client, they can use it for every styled shoot. It's just you need to have them sit down and think about all these things beforehand. They need to make sure that they have those model and photography releases, especially if it's in a public place. Washington, D.C., if you have a tripod, they essentially policemen can come up to you and ask for your license. So you need to know the rules of the locality where you are, especially for these styled shoots because they're a lot smaller scale and a lot more in-depth than a traditional photo shoot might be because they're bringing in dresses and silverware and sometimes cakes and things like that, and it's not just kind of like a run and take a shot and then leave. You're going to need to be there for a while. So if you set up and someone comes in and stops the shoot from happening, you're going to wish that you got those licenses up front. One of the biggest issues, I think, in styled shoots is who owns the copyright in the images and what are those attribution rules for those images going to be. The photographer kind of rules the roost here because they are the one that is taking the images, and they are the one that's producing the fixed medium of expression that results in a copyright. So your photographer has a lot of leverage here. If you're drafting it for the photographer, you want to make sure that they license the images to the other wedding vendors that are involved in the shoot, and that they make sure they keep the copyrights and don't transfer the copyrights away. You want to make sure the attribution rules are clearly set out in the agreement with them, which means who is allowed to share them on social media and under what circumstances. How do they give the photographer credit for the images that they took? Are the other vendors allowed to submit to industry blogs or magazines? If they do, and there's a fee involved, who's in charge of the fee? If someone submits the photographer's photo and they get paid to do so, does the photographer get any sort of cut of that? Are the other vendors allowed to use those images in their portfolio? Questions like that are the things that you need to think about for your client and advocate for your client and address them up front. I usually like to have clauses that say any sort of social media posting will link back to the photographer's either Instagram, Facebook, website, whatever the social media platform they're using. Anytime another vendor uses the images, they link back to the photographer, and usually that is extremely manageable and doesn't get trampled on. So it's just things that you need to be thinking about to make sure your client's interests are protected.